Simplifying the probate process does not mean cutting corners. We had a probate that our law firm handled a number of years ago, and a lady passed away, and her ex-husband came forward with a completely bogus will. He claimed that she signed this will with an X, but the lady never signed any other documents with an X. Anyway, because we didn't serve a notice to creditors, I'll finish that story a little later on in the video. So what if I told you that navigating the probate process after losing a loved one could be less overwhelming and more empowering? Welcome to Probate Made Simple, where we turn complexity into clarity. Hi, I'm attorney Paul DeLaurie, and for over 25 years I've been helping families through the probate process. Today we dive into simplifying the journey, ensuring that it's not a burden, but a pathway to honoring your loved one's legacy. Okay, what is probate first? Probate is a court proceeding for administering a deceased person's estate or their stuff. Now, it's crucial to identify what assets need probate and which don't. For example, jointly owned property or assets in a trust typically don't need to go through the probate process. Also, sometimes you can skip probate because of the value of the assets at stake. Now, specifically, small estates can sometimes bypass formal probate, saving time and reducing legal complexities. However, this depends on the specific situation. I've recently handled a probate for an estate worth about $20,000 because there was conflict in the family and we just had to go to court in order to administer it. Now, finding the will is another crucial step. Now, it could be with the person's attorney, the deceased person's attorney. It could be among personal documents. It could be in a probate binder. And here, let me show you. Here, for example, is a probate portfolio. And this is what our firm puts estate plan documents in. So typically, if it was done by an attorney, it's going to be in some kind of a book like that. It could be blue, red, green, something like that, but it looks kind of important. So, and a handwritten note can sometimes be considered a will. Now, depending on the state you're in, we're in Arizona, and a handwritten will it's called a holographic will. So keep an open mind. You're looking for something called a will or a last will and testament, or you're looking for something signed by the deceased person saying that certain property or money is supposed to go to a person or persons, and it's signed, and it's in the handwriting of the deceased person. Now, so it doesn't necessarily need to be a formal legal document to qualify as a will. I know this doesn't sound like I'm simplifying things, but having a will almost always simplifies the whole process, if you can find one. So if you're taking on the role of personal representative, understand your responsibilities. Now, this includes filing the right documents with the court and possibly taking trainings required by the court. Here in Arizona, there are certain trainings that you have to do. Check with the court rules or talk to your probate lawyer about that. Next, you need to be sure to notify beneficiaries and creditors promptly. This involves publishing a notice to creditors and sending direct notifications to people. And again, the statute in the state is going to say how exactly you do that. Now, think of creditors as anyone who might want something from the estate, even though they aren't in the will or they aren't a family member. Now, years ago, I handled an estate, and the deceased lady's ex-husband filed a bogus will. Like I mentioned, it was signed with an X, completely bogus. Admittedly, our law firm failed to think of the ex-husband as a creditor, and it costs time and money. So think broadly in terms of who a creditor is. Missing this step can complicate things significantly. Next, accurately value and manage the estate. Now, this might require professional appraisals, especially for real estate or valuable personal property. Be thorough and objective in the process. And talk to your probate attorney about whether a professional appraisal is required. And there are other rules in terms of doing an inventory and doing accountings and how you track things. For sure, don't commingle things. Do not commingle assets, okay? That will greatly complicate things. So again, your probate attorney can guide you through all this process. Ensure that all legitimate debts and taxes are paid. Prioritize these payments correctly to avoid personal liability. And remember, settling debts is not about speed, but accuracy and legal compliance. Here in Arizona, there's a specific statute that says which creditors get paid first and how to handle creditors if there isn't enough money for all of them. For example, the statute also says how you can deny a creditor claim. Now, only after settling debts and taxes should you even think about distributing the inheritance to people. The timing of distributions can vary, and it's crucial to follow the legal procedures to avoid disputes. Finally, close the estate. This can be done informally or formally depending on the situation. A formal closure might be necessary. Formal meaning you go to a judge, there's a hearing, and that might be necessary in cases of family disputes or complex estates. Dealing with probate can be daunting, but it's a journey you don't have to walk alone. Understanding the process and when to seek legal advice can make all the difference. At Probate Made Simple, we're here to guide you through each step. And remember, you're not just settling an estate, you're honoring a legacy and caring for your family's future. Visit our website at probatemadesimple.com for more resources and support on your journey.